Good evening, ladies and gentlemen, and welcome to this evening's Brick Court seminar on recent developments in the law of Bills of Lading. I'm delighted so many of you were able to come, perhaps even more delighted that so many of you chose to come. I'm pleased to say that tonight we have 4 members of Chambers who will be speaking tonight in relation and dealing with various recent cases. As I'm sure you appreciate, it's always good to have a theme linking the various talks, and today predominantly we have that theme being food. Richard Aikens will be talking about tins of tuna, very big tins of tuna, but tins of tuna no less. And he'll be doing that in the context of the applicability of the Hague or the Hague Rules and the package limitation. Michael Boulding will also maintain a fishy theme, this time fish oil, and again in the context of the operation of the package limitation. Richard Lord will move on to the dessert course and bananas, this time in the context of considering an endorsee's right to recover damages under Section 2.4 of COGSA and the operation of the mere receipt rule. And he'll also give us a bonus talk on the thrilling subject of Barratry and the exclusions from liability under the Hague Rules. Only Jo Box has let me down. Steel coils in her case, I'm afraid, and try as I might, I have not managed to relate that to our principal theme of food. Nonetheless, Jo is talking on an interesting topic, the extent to which it's possible to resist the enforcement of a New York Convention award on the ground that it would be contrary to public policy to enforce the award by reason or by virtue of its having involved fraud on the part of the claimant, in this case by the use of forged bills of lading. Now, I'm told that some of the literature suggests that our finish time is 8:30. It's not. It's not. We intend to be around an hour and then maybe some drinks until 8:30, but we certainly won't be talking till 8:30. So to get us underway, Richard Aikens.
Thank you. Well, as Mike has already indicated, my theme, or at least the subject matter of the theme, is tuna, bluefin tuna loins to be precise. Now I've got to make sure I can do this. There we are. I've found a picture of a bluefin tuna loin. I didn't even attempt to find a picture of tuna other parts because I thought it might be too disgusting, and no description is given in the Court of Appeal's judgment on what those parts were. So we'll just stick with the loins, although the other parts do feature. So who were the parties? Typically international case where you have Japanese receivers, Moller Maersk, not surprisingly carriers, the biggest container line in the world, and several ships involved, but Maersk Tangier is the important one. The shippers, a Spanish company. And there were, to start with, a lot of super freezer containers involved. They were going to go carrying fish and we don't know about the others, but certainly fish in 3 of them, from Cartagena to Japan via Valencia and Singapore. And the containers have at least a lot of tuna in them, and rather large lumps of tuna as well, as you can see. The shippers stuffed the containers. The loins, and this is important from the point of view of the argument later, were not put in packages and they weren't wrapped. They were just stuffed straight into the containers, but the other parts were in bags. All 12 went on to the Maersk Tangier to start with. She sailed for Valencia. 3 of the containers were then transferred to the Maersk Eindhoven, and then an alarm sounded in one of the containers, and that was unpacked, destuffed, and the contents were put into a replacement container. Then when they were delivered, the allegation was that there had been damage during carriage to the tuna, and the receivers sued the carriers and claimed a lot of yen and rather fewer amounts of pounds, if that's how you did it, calculated it. Right, the 3 containers were received, the Court of Appeal judgment tells us, pursuant to a contract or contracts of carriage on Maersk standard terms. And there's not much in the judgment about those terms, and all it says is that it was agreed by the parties that there was an implied term that the shippers were entitled to demand that a bill of, or bills of lading be issued by the appellant. And originally there was a bill of lading, a straight consigned bill of lading, naming Koyoku as the consignee. No separate bills of lading were issued in respect of the 3 containers, which you remember were as it were detached, hived off, but non-negotiable sea way bills. And each of those stated 1 container said to contain, and then a number of pieces of frozen bluefin tuna loins, and the number of the individual tuna loins was given for each of the container. So it was agreed that any liability of the carrier was to be governed by the Maersk terms, and the big issue on issue number 1 was whether it was the Hague Rules or it was the Hague Rules, Articles 1 to 8. There were a lot of preliminary issues before Mr. Justice Andrew Baker, but only 3 were considered on appeal, and I've identified those 3 there. The first was whether or not the Hague Rules or the Hague Visby Rules applied, and then, of course, as you will all recall, the rules as far as package limitation are concerned are very different under the Hague Rules and the Hague Visby Rules, and that was the significance of that. If it were to be the Hague Rules, then what was the relevant package or unit? That was called issue number 2, and if it was the Hague Visby Rules, then is it the containers that are the relevant package or unit? Alternatively, are the individual pieces of tuna, as referred to in the relevant document for each container, to be taken as the package or units for the purpose of Article 4, Rule 5C. There was another issue which is characterised as being part of issue 3, but I think is really part of issue 1, which was dealt with by the Court of Appeal as a new argument which came up there, and that was the question of whether or not the number of packages or units had to be enumerated in a rather more elaborate way for the purposes of Article 5, 4, Rule 5 and C, and the fact, was it significant that the 5C of the Hague Visby Rules refers to enumerated in the Bill of Lading, and no Bill of Lading was issued, in fact, in that case, in respect of the relevant containers. As I say, I think that really rather goes more to issue 1 than issue 3, but it was argued in that way in the Court of Appeal. So, what did the judge decide? And I've kept this description of it very short, but Mr. Justice Andrew Baker's judgment runs to more than 100 paragraphs, in fact. Mind you, so does the Court of Appeals, including Lady Justice Gloucester's judgment, which is 2 words, that runs to 102 paragraphs. So no shortage of explanation on the part of both the judge at first instance and the Court of Appeal judge. But Mr. Justice Andrew Baker decided, after long and careful analysis, that the issue of liability, the alleged damage, was governed by the Hague Visby Rules. He dealt with the contrary position, which all must have been obiter, therefore, if liability were to be governed by the Hague Rules, then in relation to the tuna loins, each of the individual pieces of tuna constituted a separate unit, and each of the frozen parts constituted a separate package for the purpose of Article 4, Rule 5 of the Hague Rules. But given his decision on issue number 1, looking at the Hague-Visby rules, he decided that the individual tuna loins were the packages or units as packed into the containers, and since they were identified and enumerated in the waybills as the cargo, by the operation of Article 4.5c, they were units for the purposes of that, and packages or units for the purpose of Article 4, Rule A. Also, as the words package or unit must have the same meaning in both paragraphs. So he came out effectively in favour of the receivers, and so it was the carriers that decided to appeal on all these issues. And I have set out on the next slide but one, a summary of their arguments, but I thought at this point I should remind you of what the relevant sections in COGSA 1971 says, and also what the Hague-Visby rules say. Article 1b is the same in both the old Hague rules and in the Hague-Visby rules. But sections 1, 2 and 4 of COGSA are obviously central. The first in 1.2 giving the Hague-Visby rules the force of law, and then section 1.4 making the qualification that nothing in this section shall be taken to applying anything in the rules to any contract for the carriage of goods by sea unless the contract expressly or by implication provides for the issue of a bill of lading or any similar document of title. And it's the bit after unless that was the centre of the argument for the purpose of issue 1, so far as the Act is concerned. Then within the Hague Rules itself, Article 1b, the definition of contract of carriage applies only to contracts of carriage covered by a bill of lading, and it was the word covered that was the centre of the argument, second part of the argument on issue 1. Any covered by a bill of lading or any similar document of title insofar as such document relates to the carriage of goods by sea. Then, just to remind you of Article 4 of the Rule 5 of the Hague-Visby rules, the relevant bits, and it's the second part of A, which identifies what the amount will be per package or unit, or 2 units of account per kilogram of gross weight of the goods lost or damaged, whichever is the higher. And then the new bit that was of course central to the changes in the Hague-Visby rules, about which there was a great deal of debate during the conference which led to it, to deal with container traffic, which had begun to become important in the 60s. And it's sometimes difficult to remember that it was as long ago as that, actually. But it was beginning to be important then, hence the need for this change. So where you have a container, to consolidate goods, the number or package units enumerated in the bill of lading as packed in such article of transport shall be deemed to be the number of packages, etc. So the words enumerated in the bill of lading as packed in such article of transport were at the centre of the argument for the purposes of the third issue. So what were the arguments that were being put up against Mr. Justice Andrew Baker's judgment by Sarah Masters, Queen's Counsel, on behalf of the owners? And she said, first of all, you've got both the tests in 1.4 and Article 1d of the rules have got to be satisfied before the carriage can be subject to the Hague-Visby rules. And she emphasised in particular that the carriage has to be covered by a bill of lading under Article 1d. And she says, how can it be when there is no bill of lading? She submitted that the French text supported this, and in the Hague Rules, that's equally important. And of course, in the Hague Rules, and it's the same wording in each, the French text was the authentic text. And so she's pointed out, reminded the Court of Appeal, if they needed it, that seaway bills are not bills of lading or any other kind of document in title. An extended meaning to covered by a bill of lading isn't justified, she submitted, on the basis of principal authority. So you can't get to Article 10 of the Hague Rules, you just don't get past the starting point. And they can't be applicable by contract either. So that was issue 1. Issue 3, she relied in particular upon the majority of the Federal Court in Australia's decision in the El Greco case and submitted that should be adopted. And she focused in particular on as packed in such articles of transport and said there's got to be more than just a number of packages identified in whatever document it was, and to indicate that there was some kind of package itself rather than just the bare loins, as it were. And there was also a respondent's notice, which in the event didn't actually become relevant. So, what did Lord Justice Flow say? He gave the only judgment, as I say, Lady Justice Gloucester simply said, "I agree." And he looked, first of all, at the question of what is meant by covered by a bill of lading in Article 1b, and he said it's enough that the shipper is contractually entitled to demand the issue of a bill of lading. Pirenne and Cindia, Mr. Justice Devlin, had established that a long while ago, and he said that things had not been changed by the Happy Ranger and the Raffaella S, and rejected the submission that they were distinguishable. There was no distinction between the effect of Article 1b of the Hague Rules and the same wording and the Hague Rules, nor is the fact that in this case a seaway bill was later issued relevant. So he submitted he found that both requirements of Article 1b and Section 1.4 were satisfied. He also rejected the argument on the French text because he said there was no authority to support that, and the new argument that Miss Masters produced based on Article 10, he also rejected on the basis that you had to give a purposive interpretation to the words every bill of lading relating to the carriage of goods as meaning a contract of carriage which is covered by a bill of lading or similar document of title consistent with Article 1b. Then the argument based on Article 4.5c he also rejected, and effectively he said that there had to be a rather more expansive construction that was given to that. So, what about issue 3, Article 4.5c? He said it was clear, there wasn't any difficulty about it, and you didn't have to show that they had been otherwise packed. He relied on what Lord Justice Diplock had said in the course of the Travaux, and that there wasn't any necessity for anything more. So he rejected the idea that the majority in El Greco should be followed. So that was, in essence, the decision. Was he right? Yes, in my view, he was right. They were right to come to the conclusion they did, and I've set out very briefly my reasons for saying that. The Hague Rules, you've got to start with Section 1.4. it's got to provide for the issue of a bill of lading. The contract of carriage in this case, which predated the bill of lading, as it does in almost every case, is evidence of its terms, and that did provide for the issue in the sense that Mr. Justice Devlin said in Pirenne and Scindia. So you get over that hurdle, then Article 1b, even if 1.4 is satisfied, you've still got to come within 1b, but it seems to me that Lord Justice Flow is right in saying if there were any difference between what's contemplated by Section 1.4 and Article 1b, then there would be difficulties, and so he found that they effectively meant the same thing. Having found that both prerequisites were satisfied, there was then the potential difficulty of Article 10, but he solved that, in my view, correctly by giving this a rather more extended interpretation. A slightly bold approach, I think, but one which makes commercial sense. Then issue 3, a much simpler issue to my mind, and the only question is whether or not you had difficulties because of the reference to a bill of lading, but by reason of verbal manipulation he got that to work, and I think he was right to do so. So a conclusion is a victory for pragmatism over formalism. Any other conclusion would have been wrong, and we will have to do some beefing up of our views on these issues when we come to do the 3rd edition of Bills of Lading, which we are about to start work on. So there, rather briefly, but perhaps not briefly enough, is what I had to say on the subject.
Thank you, Richard. And in fact, you came in. You actually came in under time. So, and for our second instalment on package limitation, Michael.
Right, moving from tuna loins to fish oil. I'm going to discuss, how do I change the slides? Okay, all that.
Presumably you just continue on.
Okay. Bin Lusterdin and Sea Tank Shipping, otherwise known as the Acacia. The question in this case was whether the limitation provisions in Article 4 of Rule 5 of the Hague Rules apply to bulk cargoes. Specifically, the issue is whether the term unit in Article 4, Rule 5 means a physical item of cargo, or instead refers to a unit of measurement used by the parties to quantify cargo, for example, its weight or volume. That issue has been the subject of a long-standing debate. Judges and commentators have occasionally expressed opinions on this point over the years, but the Acacia is the first English case that squarely addresses the issue. You might find that somewhat surprising, given that the Hague Rules were adopted over 90 years ago. And the issue is of some importance, because if unit in Article 4, Rule 5 means a physical item of cargo, and not a unit of measurement, then a carrier will not be entitled to limit its liability under the Hague Rules in respect of bulk cargoes. This problem does not arise in relation to the equivalent provision in the Hague Visby Rules, because that provision expressly contains a limitation of liability based on the gross weight of the cargo. The facts of the Acacia were quite straightforward. Sea Tank Shipping was the disponent owner of a tanker which transported 2,000 tonnes of fish oil from Iceland to Norway, pursuant to a voyage charter party entered into with Bin Lusterdin. The charter party was on the old London form, clause 26 of which stated that the ship owner was entitled to the like privileges, rights and immunities as are contained in Article 4 of the Hague Rules. Article 4, Rule 5 of the Hague Rules limits the carrier's liability for any loss or damage to the cargo to £100 per package or unit, unless the nature and value of the goods have been declared by the shipper and inserted into the bill of lading. The crucial words in that provision for these purposes are package or unit. About a quarter of the fish oil was found to be contaminated on arrival in Norway. Bin Lusterdin brought a claim against Sea Tank Shipping for loss suffered as a result of that damage, amounting to some $370,000. Seatank accepted liability in principle, but said that it was entitled to limit its liability to £100 per metric tonne of damaged cargo based on Article 4, Rule 5 of the Hague Rules, which would have reduced the damages to around £55,000. The parties agreed that that limitation argument should be determined as a preliminary issue. Seatank advanced two arguments. At first instance, Seatank's primary case focused on the nature of the charter party. It argued that when read as a whole as a contractual term of the charter party, the parties must have intended Article 4, Rule 5 to apply to bulk cargoes, because the charter party was specifically for the transport of a bulk cargo. Seatank also argued that Clause 26 of the charter party clearly indicated that Seatank would be entitled to limit its liability in respect to the bulk cargo in question in this case. Its other argument was that unit in Article 4, Rule 5 should, in any event, be read as a reference to the unit of measurement used by the parties to denominate or quantify the cargo in the contract of carriage. As to the first of those arguments, Mr. Justice Cook, at first instance, said that Clause 26 of the Charter Party simply meant that Seatank could rely on the privileges, rights and immunities of Article 4, Rule 5 of the Hague Rules only where the provisions of Article 4 are applicable. So if the word unit in that provision is not capable of applying to bulk cargoes as a matter of construction of the Hague Rules, it cannot apply merely because it has been incorporated by reference into a charter party for the carriage of a bulk cargo. In the Court of Appeal, Lord Justice Flo, with whom Lord Justice David Richards and Lady Justice Gloucester agreed, also stated that the meaning of Article 4, Rule 5 of the Hague Rules did not change merely because it had been incorporated by reference into a charter party for the transport of a bulk cargo. As a consequence, the real question was the correct construction of the term unit in Article 4, Rule 5 of the Hague Rules themselves. As to that argument, at first instance, Mr. Justice Cook said the term unit in Article 4, Rule 5 was capable, as a matter of ordinary language, of meaning a unit of measurement, but that read in context, it meant a physical item for shipping and not an abstract unit of measurement. The Court of Appeal agreed with that conclusion. Lord Justice Flo set out 4 reasons why he considered that the term unit in Article 4, Rule 5 means a physical item of cargo and not a unit of measurement. First, the word package in Article 4, Rule 5 plainly refers to a physical item, and the use of that term together with the term unit suggested that the latter was also referring to physical items, albeit ones that are carried without packaging, such as cars or indeed tuna loins. Secondly, he said that this interpretation was supported by Article 3, Rule 3b, which states that after receiving the goods, the carrier shall issue a bill of lading to the shipper showing, amongst other things, the number of packages or pieces or the quantity of weight of the cargo. He said that that provision showed that the Hague Rules, when they intended to refer to quantity or weight, did so expressly, as distinguished from a package, unit or a piece. Lord Justice Flo regarded the term unit as synonymous with the word piece, and both are intended to refer to physical items rather than a unit of measurement. Thirdly, Lord Justice Flo rejected Seatank's argument that the meaning of the term goods in Article 1 of the Hague Rules was of any assistance in ascertaining the meaning of the term unit in Article 4, Rule 5. Whilst the definition of goods in Article 1 is very wide and plainly includes bulk cargoes, that does not mean that the term unit in Article 4, Rule 5 must necessarily apply to bulk cargoes. Fourthly, Lord Justice Flo said that practical problems would be created if the word unit in Article 4, Rule 5 could mean either a physical item, such as a car, or a unit of measurement. That would mean that the term had different meanings depending on the type of cargo. Moreover, if a bill of lading specifically specifies both the number of unpackaged physical units and also the weight of the cargo, it would be entirely unclear what level of limitation should apply. The same problem would be created if more than one unit of measurement is included in the bill of lading, such as both weight and volume. Lord Justice Flo said that his conclusion that the term unit in Article 4, Rule 5 means a physical item for shipping and not a unit of measurement is confirmed by the travaux préparatoires of the Hague Rules. Those documents showed that Article 4, Rule 5, as originally drafted, contained a weight or volume limitation, but that was removed during the drafting process and was never reinserted because the drafters took the view that a limitation provision for bulk cargo was not needed. It was noted that at the time the Hague Rules were adopted in 1924, the price of bulk cargoes would have been seen as so low compared to a limit of £100 per unit of measurement, whatever that unit might be, that the limitation would have been regarded as irrelevant. Well, Justice Flo emphasised that he was not suggesting that the Hague Rules must be interpreted by reference to 1920s economics, but simply that this historical fact explained why no one considered it necessary to insert a provision in Article 4, Rule 5 applicable to bulk cargoes. Earlier editions of Scrutton on Charter Parties suggested that unit in Article 4, Rule 5 could mean customary freight unit, but Lord Justice Flo noted that the conclusion that the term unit in Article 4, Rule 5 means a physical item was supported by both the majority of academic commentators and also by cases at the highest level from Australia, Canada and New Zealand. So, standing back, whilst the conclusion in the Acacia may be of some concern to carriers of bulk cargoes, the decision at least provides some certainty as to the effect of Article 4, Rule 5, and it seems to me to be a correct interpretation of the rules. The question in the Acacia was not whether it would be rational or desirable to provide a limitation provision for bulk cargoes, but whether the language in Article 4, Rule 5 applied to such cargoes. Moreover, interpreting the word unit in Article 4, Rule 5 as indicating a unit of measurement as well as a physical item would create serious practical problems. In any event, in order to avoid any difficulties created by this decision, carriers are always free to seek to include a provision in their contracts deeming the word unit in Article 4, Rule 5 to mean a unit of measurement. And the parties are, of course, also free to specify in their contract that the Hague Visby rules should apply, in cases where those rules would not otherwise be applicable. The Hague Visby rules do include a limitation provision based on weight or quantity, so the problem I've been discussing here does not arise in that context.
Thank you very much. We move on. The dessert course. Richard.
Well, good evening, ladies and gentlemen. I don't know how sweet you'll find the dessert course. I'm going to try and deal with two cases in my allotted 20 minutes. In fact, I was going to be greedy and try and deal with three, but I decided in the end that the Songa Wind should get the cut, and the chopper was that even though in one sense it's an interesting case on letters of indemnity, it's mostly on the facts. So I'll try and cover two cases, both of which raise issues of law, and the first of which is the Baltic Strait. And I thought this was interesting on a number of levels, partly because it shows that even though there have been hundreds of decisions and you'd think they've run out of points to argue on relatively commonplace facts, this case illustrates that quite knotty points of law can arise on very straightforward facts. And those are set out on the screen, but it's essentially C for Comaco, sold some bananas to A, and C chartered a vessel under a voyage charter from the owner who issued the Bills of Lading for the voyage from Ecuador to Libya. And A was the buyer and became the Bill of Lading holder and the receiver of the bananas in Libya, by which stage they were now quite rotten, as unfortunately seems to be an occupational hazard for bananas, and depreciated in value by some $4.5 million. And what then happened is A, the buyer purported to reject the bananas under the sale contract, as again often happens, even though risk is clearly in one party. They say, well, these are rotten, I want to send them back. but the dispute between buyer and seller was settled on the basis that a credit would be given by the seller for some $2.5 million. And that, as it happened, was the same as, or virtually the same as, the proceeds of the cargo insurance that was paid to C as the seller. And what happened then, unsurprisingly, is that A sued the owners under the Bill of Lading contracts. And strictly speaking, it was the assignee of A, the cargo insurer, but that doesn't matter for present purposes. And the issue came before a very distinguished tribunal. I say that partly because it was, and partly because one of them is here tonight and may be able to shed light on what, to me, as you'll see, is to some extent a rather mysterious judgment of the court. But the issue was, could A recover the full $4.5 million worth of damages, notwithstanding that it had a credit from the seller of $2.5 million? The tribunal said yes, it could. First of all, the 2.5 million was not to be left out of account because it wasn't an insurance payment, even though it was pretty much the same in amount as an insurance payment. And because it was a credit from a seller, it was not res inter alia actos, so the credit had to be given. But, said the tribunal, that didn't preclude a full recovery by A as buyer because of Section 2.4 of the Carriage of Goods by Sea Act. And so A could recover from the owners the loss that had been suffered by C. And without going into a lot of detail on Section 2.4 of COGSA, that was an integral part of the statute, was designed to stop technical title to sue points being taken, which had been under the 1855 Act, and in particular points as to separation of loss from title to sue. And for present purposes, what's important is that it operates, first of all, under 4A, where the person with interest or right in relation to the goods to which the document relates sustains loss or damage in consequence of a breach of the contract of carriage. And then, but then subsection 1 operates to vest the rights in another person. Then the other person should be entitled to exercise those rights for the benefit of the person who sustained the loss or damage to the same extent as they could have been if vested in the person whose benefit they are exercised. And that's a bit of a mouthful, but I hope I'll make clear what the actual issue on that was. And on the appeal, although I've listed the issues in a different order from the judge, there were 3 issues. The first one was by respondent's notice, because cargo owners said, well, notwithstanding that this credit was under a sale contract, it wasn't insurance proceeds, we should be entitled to sue for the full values. We were owners of the cargo and this credit's irrelevant. Then 2 separate issues under Section 4 of COGSA. One, the carriers took the point, or the argument, that Section 2.4 couldn't operate unless there'd been a party that did have the right, in this case C, and they had lost it. And for reasons I'll develop a little, it was said that it didn't operate in that case because of the receipt-only rule. And the third issue, also under Section 2.4, was whether A could claim for losses that were in fact suffered by C as charterer, because as explained at the beginning, C was in the position of voyage charter of the vessel. Well, on the first issue, cargo owners succeeded, and it was held, by reference in particular to 2 cases I put on the sheet, that A was entitled to sue for full damages, and it didn't matter that A had received a partial credit from the seller. And provided that A owned the cargo at a material time, it didn't matter whether A owned it at the time the cargo was damaged. And the judge referred, this was Mr. Justice Andrew Baker, who referred to a certain symmetry in the position. So if you were a seller, you could recover full damages even though you'd been paid the price for it, and if you were a buyer you could recover full damages even if you'd had to, even if the seller gave you a credit. And so on that basis, on the respondent's notice point, the cargo owners succeeded. On the second issue, things got a bit more complicated as a result of the as a result of the receipt-only rule. And just to divert for a moment on that, the basic receipt-only rule is well established and well known. If a charterer of a vessel takes a bill of lading, the bill of lading is a receipt only and does not contain or evidence a contract of carriage. The charter remains the governing instrument. And that's only a prima facie rule which can be displaced if the bill of lading contract is not closely connected with the charter party, but here it was because it was a charter party providing for issue of congen bills. And the difficulty with the receipt-only rule comes in its interaction with Cogs 1992, or in the case of the Dunelmere, the predecessor, the 1855 Act, allowing for transfer of rights. And the Dunelmere was a case where the goods were shipped and the bill of lading did operate as a contract, but it was then endorsed over to the charterer. And the Dunelmere showed that the statute transferring the rights and liabilities, in that case the 1855 Act, did apply, but also the receipt-only rule applied. So in the hands of the charterer, the rights of the charterer are still those of the charter party, not the rights on the bill of lading. And the converse of that is where you've got a charterer who takes the bill and then endorses it over. And in the words of the Hayne and Tate and Lyle case, a rather odd conceptual device where on endorsement a contract springs up even though there wasn't one before. But in any event, the first argument was that, as I've indicated earlier, Cogs of 1992 couldn't apply unless there was already someone who'd had those rights and lost them, and C, in this case, never had any rights under the bill of lading contract because it was the charter, and therefore it couldn't apply for that reason. And the judge rejected that and said that there was no reason of principle or wording to import that limitation, pointed out that on that argument, only holders downstream of the sufferer of loss could recover, not those upstream, and he rejected various other arguments as well. So that didn't stop the section applying, but on issue 3, the position was rather more complicated. And I have to confess that even though I've read the paragraphs in question in some detail several times, I find it difficult to divine the exact reasoning, and Mr. Justice Andrew Baker is extremely intelligent, so I'm sure it's a failing on my part, but he said that he would not accept an argument that was put, and this was a simple argument that seemed to me to have some force, which is that because the reference in section 2.4 was a reference to suffering loss and damage in consequence of a breach of the contract of carriage, and that meant the bill of lading contract, that could not apply where it was the charterer who'd suffered loss and damage because that was in consequence of the breach of the charter. That seemed to be a relatively straightforward argument which was pressed before the tribunal and again before Mr. Justice Andrew Baker, but that was rejected as too artificial. And what he did say was what's set out on the screen there, and I'm not going to read, but he made it clear that what you had to do is look at the fictional position as though the original party had vested in it the rights of suit under the bill of lading and see the extent to which they could invoke those rights. And applying that, he said no counterfactual factual circumstances were necessary in order to conduct that inquiry. And on the facts of this case, the rights that would have been vested in the charterer were rights under the charter party, and therefore A, as holder of the Bill of Lading, could not avail themselves of the terms of the section. And so that reasoning, and I'm in the interest of time not allowing you to dwell too long on those paragraphs, you can read them in your own leisure time. Well, clear as a bell, I don't know, not to me, more Delphic than the Delphini, possibly. I certainly wouldn't make any reference to bananas because I genuinely have great respect for Mr. Justice Andrew Baker. But what I think in a sentence he is saying, and I invite views from anyone who's already grappled with this case, is that Section 2.4 couldn't assist A because had the rights been vested in C, they couldn't have been exercised because of the receipt-only rule, and there was nothing in the award to suggest that the receipt-only rule did not apply. So I'd already postulated the simplest solution, but that wasn't the one that appealed to the judge. Or, as a matter of policy, the decision of the tribunal seems to me perfectly defensible on the basis that the whole argument based on the Dalmelmian receipt rule could be seen as artificial, but it doesn't suffer from some of the other defects in the Bills of Lading Act 1855. The charterer still can claim its own loss, but overall result upheld even though the judge differed from the tribunal. Mike, how am I doing for time?
You've got about another 8 minutes.
Right. Okay, so on now to the Lady M. Again, appeals to me because it's nice, simple facts. And here there was carriage of cargo on Hague Rules terms, and a fire was started in the engine control room deliberately by the chief engineer. And this was a trial of preliminary issues on agreed and in some cases assumed facts, and it was agreed that the chief engineer intended damage to be caused, perhaps not surprisingly, although it was emphasised that he might have done this for various reasons, including because he was stressed because of the illness of his mother, or possibly because he was insane or suffering from a mental illness, or possibly just for the fun of it. And so that was left open, it was because that was left open, the precise mental state, that the issues, I'm telling the end before I've done the middle of the story, which no decent novelist or storyteller would ever do, but just so you know where we're going on this, the issues were, could owners under the Hague Rules be relieved from liability under the fire exception, Article 4.2b, fire unless caused by actual fault or privity? Carrier, answer was yes. Could they be relieved under Article 4.2q, which is any other cause arising without fault or neglect or privity of the, actual fault or privity of the carrier, or without fault or neglect of servant or agents? No. And did the conduct of the chief engineer constitute Barratry? Well, in the end, that wasn't determinative, but answer was maybe, because his mental state was unclear. And you may think that the decision on Article 4, Rule 2b, given the wording of the rule with its own self-contained proviso, was pretty much a foregone conclusion. But it involved the rejection of a number of quite ingenious arguments on the part of cargo interests. First of all, they said that this conduct of the chief engineer constituted Barratry. Barratry is not something that shipping lawyers come across very often. Show of hands, hands up everyone who's had a case about Barratry. Yeah, great, yes. Ah, excellent. Well, I won't ask you, I'll ask you afterwards about it. But anyway, it doesn't come up very often. Partly because it's left out of the Hague Rules. And that was the core of cargo interest argument, saying, well, Barratry was a common peril, and At one stage in the Hague Rules conference, there was discussion of whether it should be excluded or not, and it came out of the list of excluded perils. Therefore, it must have meant that when fire was referred to as accepted, it didn't include fire that was caused in a Barratry manner. And that was unsurprisingly rejected by Mr. Justice Andrew Popplewell, and he also rejected, both as incorrect and irrelevant, an argument that in exception clauses accepting fire, that was not usually covering negligently or deliberately caused fire. So the judge confirmed that the rule on fire means what you think it would from reading it, that it covers any fire, however caused or started, unless it was actual fault or privative of the carrier. And that means the alter ego of the carrier and all those various tests. Article 4.2q, again, not particularly surprising that the chief engineer, who's clearly a servant in the anachronistic language of owners, was at fault in setting fire to the vessel. But what was quite interesting is the approach, because the judge said, because what happened is cargo interests raised an argument which was developed to the effect that this couldn't be, owners developed an argument to the extent this couldn't be relied on if there was a frolic of the master's own and wasn't acting in the course of employment. And they said, well, setting fire to an engine room is not in the course of your employment, it's a frolic, it's the exact opposite of what you're supposed to do, and query whether that applies. And the judge said, well, it didn't actually matter, because whether you looked at scope of employment in terms of the English rules of law on tort or an agency analysis, in either event, the chief engineer's conduct was caught within the scope of employment and was fault or neglect by the servants of the carrier, and so the exception couldn't apply. But the judge did say that there could be some cases where scope of employment was narrower than an agency analysis, and he preferred an agency analysis. In other words, was the crewman or agent concerned acting on behalf of the carrier within normal agency principles as set out in the Global Meridian case and others, rather than in terms of the English law of tort on vicarious liability. And perhaps the most interesting in an academic sense part of the case was the definition of Barratry itself. And why I say in an academic sense is that it was ultimately irrelevant to the decision in this case, and as Barratry doesn't appear in the Hague Rules, it's unlikely to be relevant to many carriage of goods by sea cases. But the judge did give some detailed consideration to Barratry, which is an marine insurance peril, and the scope of this basic concept of a crew member doing something by way of serious wrongdoing against owners' interests. And one of the issues, and I don't have time to go through all the various stages of analysis, mental state as to the act, or as to whether damage would be caused, or whether it was a crime, or whether it was a wrongdoing. But the most interesting thing to my mind, and most controversial aspect to my mind, is that Mr. Justice Popplewell, although he said, yeah, English law, so English law governs things such as recklessness with regard to breach or damage, what about if the crew member was insane, and insanity is used as a defence to a criminal type of Barratry? And Mr. Justice Popplewell said, well, in that case, we don't want to use the very odd McNaughton rules in English law. Any mental element on criminality should be such as to assume general international recognition as giving rise to criminal liability. And that, to me, poses a problem. What is the international general accepted law on criminality? Do you take as a common denominator the fact that all civilizations recognise it a crime? Do you go to public international law and the ICC jurisdiction? Do you get expert evidence on the point? Seems to me a difficult concept, particularly when mixed with the English law elements on other parts of the mental ingredient. But Barratry, that is the definition in paragraph 22. I won't read it out, but it's basically, it's acts by the crew member against the interests of the owner that involves serious wrongdoing, such as crime or serious breach of duty. And because the agreed and assumed facts embraced a number of possible states of mind of the chief engineer, the preliminary issue was answered, maybe, it all depends. So that's a brief excursion through the Lady M and Barratry, and that's all from me. Oh, sorry, Ellie.
One question, if you don't mind. If the chief engineer was mentally ill or insane, it doesn't that go to the question of whether the vessel was made seaworthy at the commencement of the voyage? Because if you have someone insane in charge of your engine room, then the vessel is not seaworthy.
I think the answer is, and I don't want to trespass into Joe's time, but I think the answer is it undoubtedly would be if he was insane at the beginning of the voyage, because you have to have a competent crew. Yeah, but it was suggested he might have been deranged by various other factors, and also it would be subject to due diligence defence. So unless owners had reason to suppose when they recruited him or before the voyage he was insane. But it's a good point, it wasn't running the case, but certainly I think insanity is one of the Eurasian dream categories of incompetence, unsurprisingly, because having insane crewmen isn't a great idea.
Yeah, thanks.
Thank you, Richard. You managed to expropriate Richard's spare time. So we're now back on time. Joe.
Thanks, Mike. To round off today, I'm going to talk briefly about a recent case involving forged bills of lading, which is quite interesting because it looks at what the exception for contrary to public policy means when you're deciding whether or not an arbitration award should be enforced in this jurisdiction. So the case is the Court of Appeal decision in RG Trading UK Limited and Sinacor International Limited. As most of you will be familiar, Section 103 of the Arbitration Act makes it clear that enforcement of a New York Convention award can be refused if such enforcement would be contrary to public policy. And the recent Court of Appeal decision demonstrates quite how limited the scope of that exception will be. This was the first time that an appellate court had considered the issue since 2000, when the Westacre case was decided. And therefore it's quite an interesting insight into how the court's thinking has evolved over the last 18 years. The facts are reasonably straightforward. The case concerned a contract to sell steel coils. As Mike said, unfortunately nothing fishy in this case. Payment was by way of an irrevocable letter of credit issued by Rabobank in the Netherlands. And originally, the letter of credit specified that shipment was to be by the 31st of July 2010. For reasons that weren't entirely clear, RG, i.e. the buyer, instructed the bank prior to shipment to change the terms of that letter of credit, so that rather than specifying by the end of July, instead it specified between the 20th and 30th of July. The point wasn't put to Sinacor, and there's no suggestion that Sinacor had agreed to that provision being changed. The coils were then loaded on the 5th and 6th of July, and the vessel departed on the 7th. And RG, the buyer, was notified at that time. Sinacor's presenting bank subsequently tried to present to Rabobank bills of lading which stated that loading had occurred on the 20th and 21st of July. It was common ground that they were forged bills of lading and that they'd been concocted in order to try and comply with the amended letter of credit. Unsurprisingly, the Dutch court injuncted payment under the letter of credit on the basis that this was a fraudulent presentation. And there were subsequent proceedings before the Chinese court for damages arising out of the failure to make payment, where again the claim was unsuccessful because the presentation was fraudulent. Sinocor then went on to sell the coils at a lower price to another party and issued arbitration proceedings in China. In those arbitration proceedings, the tribunal awarded Sinocor damages despite the fraudulent attempt at presentation on the basis that RBRG was in breach of the sale contract because it had procured the amendment to the letter of credit without agreement. And this was found to be the cause of the non-payment. The tribunal further found that whilst the forged bills of lading may have been intended to deceive the bank, they didn't deceive RBRG because RBRG already knew the real loading and shipping dates. RBRG tried to appeal this award to the Chinese court and unfortunately was unsuccessful. Then, at the beginning of 2016, Sinocor applied to the English court to enforce the award. Mr. Justice Burton made the enforcement order, and RBRG subsequently applied to have it set aside. That was unsuccessful at first instance, and there was then an appeal to the Court of Appeal on a number of grounds. First, it was said that Mr. Justice Phillips had failed to apply the proper approach to fraudulent behaviour identified by the Supreme Court in Patel and Mirza. Secondly, it was said that Sinocor's claim was really based on its fraudulent presentation of the forged bills of lading, and that the bank's failure to pay out was the real cause of the loss here. It was said as a result of that the English court should not be assisting Sinocor by enforcing the award, because Sinocor had fraudulently attempted to obtain payment and the award was tainted by fraud. The Court of Appeal, however, found no reason not to enforce the award on those facts. The court started with setting out some general principles, and it's clear from these just how narrow the exception is intended to be. The court made clear that Section 103 is predisposed in favour of enforcing New York Convention awards. Furthermore, exceptional circumstances are needed to reopen a tribunal's determination that there's been no illegality on the facts, and the earlier Court of Appeal decision in Westacre was approved on that basis. If there's no illegality under the governing law, but there is under English law, public policy will only be engaged where the illegality reflects considerations of international public policy and not purely domestic policy. And it's important to assess the degree of connection between the claim and the relevant illegality. What isn't clear from those general principles is what is meant by the sort of exceptional case, what falls within Section 103. A couple of examples from previous cases were referred to. So an attempt to enforce an award based on a contract to smuggle or to bribe will be refused on public policy grounds, as was the case in Soleimani and Soleimani. But an award based on a contract which was simply procured by bribery won't be, as was the case in Westacre. But beyond those two decisions, which was cited as examples, there's no further guidance from these general principles as to when one might be able to argue that actually one was within the sort of exceptional territory that would stop enforcement. So very similar general principles to before, but not necessarily particularly helpful. Finally, in terms of general principles, it was stated that Patel and Mirza doesn't change the approach in this context, and that actually that's looking at a different situation where the substantive claim involves illegality, rather than the case where one is considering Section 103. Applying those principles to the facts of the case, the court rejected the argument that the arbitration award was really based on the fraudulent presentation of the bills of lading, the court said there wasn't a sufficiently close connection here, and therefore public policy wasn't engaged. Further, it was said that it was not appropriate to go behind the tribunal's finding that fraudulent conduct was not causative of the loss suffered. The underlying sales contract had not been found to be illegal. And finally, and perhaps most surprisingly, this was in fact only a case of attempted fraud because Synacor's demand under the letter of credit had not resulted in it being paid. And the court said there's no public policy to refuse to enforce where there's merely been a failed attempt at fraud, rather than fraud itself. So what can one take from this decision? First, it's a clear restatement of the English court's firmly pro-enforcement approach to international arbitral awards. It shows just how difficult it will be to persuade the court to refuse to enforce an award. And it's particularly useful in that context to note that that isn't necessarily in keeping with the approach that's taken when looking at fraud in the context of letters of credit. It's clear from the decision in UCM and Royal Bank of Canada that fraud unravels all, and that the courts won't allow their processes to be used by a dishonest person to carry out fraud. And one might expect, given those sorts of strong statements that get made in that context, that an attempted fraudulent presentation would be the sort of factual scenario that would fall within the public policy exception. Where I think this gets us is that England is going to continue to be a very arbitration-friendly jurisdiction. And I think in a post-Brexit climate, that's probably a good thing. A supportive and non-interventionist judiciary can only enhance London's appeal as a centre for arbitration. But what's going to be very difficult is to work out when to advise a client trying to resist enforcement based on these facts. Thank you.
Thank you. Joe, can I suggest our panellists assemble so they can be seen?
Have we got enough chairs?
We need one more. Right, they're all yours. Yes.
Minister from UCL, thank you very much. It's a very exciting seminar. Thank you. I have a question to. I don't think it works.
It's for the camera.
Oh, okay, that's fine. Don't worry. Okay. So my question is to Michael. Thank you very much for your presentation. We see in the decision, Acacia, that the court really placed reliance on the historical approach of the Hague Rules. I'm really inclined to think that the case was not decided correctly, and my view is that by doing so, obviously the court didn't regard, it sort of ignored the party's intention to incorporate. So the incorporation in essence became ineffective because there was obviously bulk cargo under the charter party, and parties wanted to trigger the limitation, and they would like the limitation to be applicable, and that is why they incorporated the Hague Rules. So to my mind, I don't think the decision was correct, because in Kyoko case, we obviously see that pragmatism was upheld. In this case, it seems that pragmatism was not actually upheld. What are your thoughts about it?
So I think the argument that was based on the intention of the parties, whilst it's got a superficial attractiveness to it,
Yeah.
I'm not personally persuaded by that argument on the basis that clearly the only cargo in question in that case was a bulk cargo, but the parties generally just incorporated the whole of Article 4 of the Hague Rules into the contract, and there were plainly some parts of that rule that couldn't apply on the facts, the provisions about packaging, for example. So I'm not particularly persuaded by that argument. I think clearly on the basis that it was common ground between the parties that as a matter of ordinary language, the word unit could include a unit of measurement. It was open to the court to try to be persuasive. But I think what was quite important was the fact that they recognised that what they're interpreting there are international rules, and they wanted to try to take account of the general approach. And whilst in England there wasn't, prior to that case, a decision specifically on point, there have been very authoritative decisions from Canada and New Zealand, Australia, for example. And I think that's quite an important point to take account of when you're trying to interpret an international convention.
Thank you.
Another question.
Could I just ask this lady first and then come back this time?
Thank you. It's actually on a related point. I mean, the important things to me in the Acacia seems to be that the London form specifically refers to actually not the entirety, that particular part you quoted on your PowerPoint, not the entirety of the rules, and went into some lengths to incorporate specifically the delimitation provisions. Now, you have authorities in the Lowlands Orchid and in more recent Supreme Court decisions that effect should be given to all the provisions of the Chart Party insofar as it is possible to do so. And yes, and you can't jump into not applying some of these provisions. Now, if you have a bulk cargo Charter Party, and the only way you can give effect to both the bulk cargo provision and the limitation provision in the Hague Rules would be to construe a unit as meaning weight, then I find it difficult to understand why that is not what was adopted, bearing in mind what the canons of constructions are at the moment.
Clearly, there's an argument there based on the intention of the parties and the fact that the only relevant cargo was a bulk cargo. But I can't remember the specific provision, the wording of the clauses in the contract, but I seem to remember that the judge dealt with that on the basis that it did cover provisions of Article 4 that couldn't apply on the facts of the case. And given that that's right, if that's right, then really you just push back to the proper interpretation of the Hague Rules as opposed to on the specific facts of that case. And if that's the exercise you're doing, you need to look at the international approach as well as various other considerations, I think.
Yes, Article 4 is pretty mixed bag. Sorry to butt in, yeah. But it presumably wouldn't cover things like defective packing either or anything like that. So it's difficult to divine. I would have thought that wide an intent or that specific an intention. Miriam.
Thank you. Yes, please.
Thank you. I just wondered about the Sinocall case, whether if forgery had been argued rather than fraud, whether the result might have been different.
I mean, it was common ground between the parties that they were forged, and that was the fraudulent element. So I think for that purpose, the court treated them as one and the same. But I agree that in a subsequent case, sort of any way that one can run alternative arguments, I think is the way forward, because if what we're stuck with is a very narrow exception, and that there are lots of benefits of having that, but obviously if you're acting for a client who wants to try and get itself into that exception, I think being able to put the case in a number of different ways and try to push them as independent means of getting within that part of 103 probably is the way forward.
Because the forgery was not attempted, it was actually accomplished.
Yeah.
So it must have made a difference.
No, I think that's an interesting point, and I think that's something that probably sort of, if one looks at the judgment, it was taken as common ground, but it wasn't pushed forward as a separate point, and maybe that would have been a more successful route, I hope.
May I just ask whether the judgment has surprised the profession?
Surprised Neil Calv. It's surprised, I think it disappointed the two who were our colleagues who were on the wrong end of it.
I think given the decisions you get in the context of letters of credit, it is quite surprising that the court was so willing to overlook that. At the same time, I think the general principles are probably less surprising, because that's very much the sort of temperature before the English courts in terms of enforcing arbitration awards.
There's a very, very strong reluctance not to enforce New York Convention awards. It's an uphill battle to persuade the court on any ground not to enforce a New York Convention award.
Well, maybe we've gone the other way too much.
Mm.
I don't know how much of a comparative study could be done, but it would be interesting to see what the position is, say, in other European courts on that. I don't know. One rather gets the impression that the English courts have gone out ahead on that of colleagues in other jurisdictions. Do you think that's fair or not?
I mean, it's difficult to say. Obviously, there's very limited reference to any sort of other jurisdictions in the context of that decision. But it does seem to me that they've really sort of, as you say, struck out ahead, possibly of other Commonwealth jurisdictions as well.
Yes, sorry.
This is a question for Richard Aikens, and perhaps in the context of the next edition of Bills of Lading. With regard to the Maersk Tangier, I was wondering where you thought that left us in respect of booking notes. Because technically, so booking note is not a charter party, so it's not accepted under the Carriage of Goods by Sea Act. And often they will, well, usually they will provide for the issue of a bill of lading. Sometimes they will provide that the bill of lading will supersede the booking note, and sometimes they won't. And often they will only incorporate the Hague Rules or the package limitation. I've seen an example of actually not having, only having articles 1 to 8 as well, so it would be just the £100 per package unit limitation without the gold equivalent. So, I mean, maybe this is just a matter of drafting of COXA rather than it being something that the Maersk Tangier can really address, but I was just intrigued to see what you think about it.
Yes, the judgment in the Court of Appeal doesn't go into the terms of the contract or where it was contained or anything at all. I think as a result of agreement between the parties. But I can't see any difficulty provided that it was that the court is able to construe from whatever contract there was, such as a booking note even, I suppose, that it was contemplated that there would be a bill of lading issued. It doesn't say whether it was a booking. It might have been a booking note in this case. I don't know. It's rather. I found it rather frustrating actually that there was so little about the contract terms. Not even actually stated that it was subject to English law, but in the judgment. But it must have been. But I think it must be taken to be fairly broad.
Yeah.
So the effect would be that if the
booking note expressly contained the Hague Rules and not the Hague Visby Rules, then the effect of the Maersk Tangier is that actually the Hague Visby Rules apply compulsorily. So therefore the package limitation will be the one in the Hague Visby Rules, which would be contrary to the express intention of the parties. I mean, that seems to be, that's what would seem to be the case in us of Maersk Tangier and the charter party only exception in COXA, which...
Well, that was the fallback argument, wasn't it, of the receivers. And that well, sorry, the fallback argument of the receivers was the Hague Visby Rules that were incorporated as a matter of contract. What the difficulty would be if the let us say the contract, the booking note, referred to the Hague Rules, but it was a 10B case. So it's not in the UK wasn't involved at all, but it was a state which had was a contracting state. Then there would be a rather difficult issue, wouldn't there, for English lawyers as to which would apply. If there would be a contemplation that a bill of lading would be issued, we're assuming, but the assumption would be that it would be subject to the Hague Rules, whereas that would seem to be contrary to the terms of Article 10. And I don't, just thinking out loud, really know what the answer to the conundrum is. But I would rather think that the English judge's view would be that once you start going down the road of satisfying Section 1.4 and Article 1b, so that you're then at what Lord Justice Lowe calls the gateway of 10. You have to go through the gateway, but the gateway is a gateway to the Hague Visby Rules and not to the Hague Rules. And so, to that extent, you're right that the intention of the parties would be frustrated, but maybe others would argue to the contrary. Or maybe not yet, maybe a retreat.
That's often the effect of COGSA, which it imposes something regardless of the party's intentions.
Well, indeed. Well, one thinks about cases like the Hollandia, where that's effectively what was being done by the English court in the end.
Well, I've got a question if anyone else has, and that's for Mr. Lord. Richard, you drew attention to the fact that in his judgment in Glencore, Justice Popplewell introduced this concept into Barratry of sort of international criminal law because he didn't think in the context of a international convention, one shouldn't be reliant on necessarily on English law principles. And you said he did exactly the same thing when he came to servants and agents and rejected the touchstone as being the English law of vicarious liability. But then he seems to have been, when he came to say, if I were able to decide it, and I would decide it on agency principles. But he then seems to have looked at English law of agency principles. Is that not a sort of inconsistency of approach?
Well, I thought it was in the sense that, but I think he justifies it in terms of a peculiar element of the defence of insanity in a criminal context. I'm not quite sure why it should matter that things like recklessness are English law, agency concepts are English law, but defence of insanity is not English law. But I agree that it does appear to be inconsistent, and as I said, it seems to, apart from anything else, introduce quite difficult evidential problems of this concept of generally accepted international law. But I agree it is inconsistent. I don't know what the judge would say if he were here.
Maybe we'll ask him sometime. Well, I hope the weather is held up, and I hope there are drinks on the terrace with some nibbles, and we're not doing too badly. It's 7:30, so let's adjourn.